Okay, good morning. And thanks for joining the Center for the Study of Europe of Boston University. It's one of the regional centers of the Pardee School of Global Studies here at BU. My name is Daniela Caruso. I am a member of the faculty of Boston University School of Law, and I am a member of the executive board of this center. This morning, I have the privilege to host a speaker and two discussants who have dedicated themselves to public international law. The importance of international law at the present time, when war is again plaguing Europe, is self-evident. Equally evident are the limits of international law as an academic discipline and its failure to bring about long-lasting peace. I welcome today a critical reflection on law in the context of relations between sovereign states, other sovereign states, and individuals who act and/or suffer on states' behalf. I am delighted to introduce one of the current visitors of the Center for the Study of Europe, Ioannis Kalpouzos. Ioannis is a visiting professor of law at Harvard Law School. He specializes in public international law, international criminal law, the law of war, and human rights law. He is co-founder of the Global Legal Action Network, an organization based in Europe that engages in pro bono strategic litigation, engaging with the themes of war and occupation, environmental justice, supply chains and accountability, migration, and border violence. Presently, Dr. Calpouzos is working on evidence in the law of targeting and on the history of the legal concept of war involving no-state armed groups. It's wonderful that we have an opportunity to hear directly from him about his current research. His research is also focused on new weapons technology, and he has been a recipient of a Harvard Law School Institute of Global Law and Policy collaborative grant on that topic. He has also worked on the history and theory of international criminal law, especially in relation to banal or structural criminality. We have two wonderful discussants today. Mohammad Al Abdallah is the Syrian researcher and activist in human rights and democracy. He is presently serving as executive director of the Syria Justice and Accountability Center. He previously worked for Human Rights Watch in Beirut, from where he covered Syria. Mohammed was imprisoned in Syria on two separate occasions for his work defending human rights and lobbying for political reform. Tom Dannenbaum, our other discussant, is assistant professor of international law at the Fletcher School of Law and Diplomacy. He writes on the laws of war, international criminal law, shared responsibility, and international judging. He has also written on peace negotiations, terrorist strategy, reparations, and the philosophical basis for punishing crimes perpetrated via the state. It is my pleasure to welcome everybody, and Ioannis, please, the floor is yours.
Thank you very much, Daniela. It's wonderful to be with you today and discuss this project. Let me share my screen and specifically my PowerPoint presentation. So this is a project which draws from different capacities that I have, specifically the academic and the practitioner capacity. And it is a project that tries to understand the nature of legal knowledge in relation to the law of targeting and how it can be used in what I call the battle to ascertain legal truth. And it is a project that is born out of a number of different frustrations, as I think all projects should be. And at the very heart of it is a frustration in terms of the tension that exists between legal truth and social or moral and political truth. The way that I have experienced as a lawyer, as an academic, and as an IHL lawyer specifically, an international humanitarian law lawyer specifically, as well as a practitioner, a tension that exists in the establishment of certain judgments and findings in relation to the lawfulness of specifically targeting decisions and airstrikes. So all of us who work in the law of war have at some point encountered this frustration. When we in horror watch the use of force and the conduct of war across the world, and we witness and we see the consequences of airstrikes, and we see the calls for accountability and the calls for justice and the calls for characterization of what is occurring, and indeed the calls for international law to take a position and decide whether the suffering that is unleashed through war and through armed violence is illegal, and yet feel to some extent stunted in providing certain positions and statements and decisions associated with what we see in the world. I mean, this, of course, has been present in the days that we're going through in the context of the aggression against Ukraine. But as we move into the war and as we move into the conflict and as we see specific situations of the exercise of violence and suffering on the ground, and as we move from the use ad bellum to the use in bello, from the law on the use of force to international and humanitarian law, this is bound to become even more complicated and even more frustrating. We come to situations and we come to conversations with colleagues and with partners and with individuals on the ground who have suffered and who have asked us to characterize a particular situation and who show us the results of a particular striking decision and ask from us to tell it like it is and to believe our own eyes in terms of the suffering and the lawfulness of what we observe. And then as IHL lawyers, we have to take a step back and go through a process of classification and analysis of the law and how it applies in a conflict, which is often characterized by the dreaded lawyerly phrase, "it depends." And that is to some extent applicable in generally in lawyering, but it is especially applicable with respect to war and with respect to the law of armed conflict. And there is that frustration between being a lawyer and being just a human being, but that frustration is highlighted and accentuated even more specifically by being an international humanitarian lawyer or a law of armed conflict lawyer, right? A specialist in the law of armed conflict. And that's also due to the nature of IHL that I will speak to today. And it's also due to a divide between the military and the civilian with respect to understanding and applying the law of armed conflict and deciding on the lawfulness of specific airstrikes. And that division is longstanding and has existed for a long time and continues to operate and can be, for example, sometimes observed also in the tension and the debates between human rights activists and NGOs and states and their military lawyers as they either defend or in any case provide advice and analysis in that respect. And it is also related to two specific points that have to do with establishing knowledge, establishing certainty, and also establishing judgment. It is a divide between the judgment that is exercised by those conducting the war, either in real time or in terms of future-oriented decision-making and action, or in reviewing their own actions with the access that they have to specific types of evidence and knowledge and materials. And it is also the judgment that is exercised, the knowledge that is necessary in order to exercise judgment on those conducting the war by external assessors. And these external assessors might be civilians, might be the public, might be organizations, activists, investigators, and might also be institutions, including judicial institutions, including courts, right? And within here, there comes an additional, if you will, tension in the legal field between, on the one hand, law of armed conflict or international humanitarian law, which is primarily a future-oriented law meant to govern the behavior of actors, and international criminal law, which is primarily an ex post facto legal regime, which is meant to govern and judge the behavior of individuals and assign potentially individual responsibility and liability to these individuals. And that, I think, sets the framework, both in terms of my intention here and my frustrations that are motivating my intentions, as well as what I want to show and what I want to discuss. So I will start by looking at the structure of the international legal argument as it comes to the law of war and targeting. And thereafter, I will look at the efforts to establish and achieve degrees of certainty in the application of the law of war. And one more caveat here. Certainty sounds like a good thing, and we are calling for it and we are yearning for it sometimes in trying to establish judgment in relation to the law of war. But I also come towards certainty with some ambivalence, because certainty is also and can be used as a tool for governance. It can be used as a tool for rationalization, and can be used as a tool that also can benefit the most powerful actors in this process in establishing, the truth in relation to the law of war. So I'll go through some of these things more quickly than others, and hopefully allow enough time for the discussants who have also wonderfully complementary perspectives from academic and practitioner sides in this respect. So the overall structure of the international legal argument, when somebody tries to apply even the basic principle that governs the law of war, namely the principle of distinction between military targets and civilians, is often regressive. You observe a situation on the ground, you observe the conduct of an airstrike, which leads, let's say, to a significant damage to civilian objects and significant harm to civilians. And your first impetus, your first position is to identify this as an attack against the civilian, a direct attack against a civilian. But in debating and in presenting this argument, the dialectic, if you will, and the conversation in relation to how this attack actually occurred and to what is its legal significance can have a regressive effect, can take step back, which leads to less certainty and, as a consequence, less accountability in relation to the lawfulness or unlawfulness of an attack. So you start from a position that there seems to be an indication that this was a direct attack against civilians, but you're open to counter arguments that there was some military target, that there was some military interest involved in this, and that therefore this might not be a direct attack, so that civilians will not be the only and the primary target, but this was an indiscriminate attack, which attacked both civilian and military targets at the same time. But this also then exposes the argument to a vulnerability that the military target was actually the primary target and the primary object of the attack, and that the attack was not an indiscriminate attack, but it was mainly potentially a disproportionate attack, so that the military aspect of the attack was the primary target, while the loss of civilian life and the damage to civilian objects was incidental, and therefore should be judged on the basis of whether it was excessive and therefore disproportionate. And that limits, again, the certainty and the potential, as well as practical potential in terms of the law and the jurisdictional instruments that you have to enforce the law, and invites an even further regression to a different argument, that in any case, the failure was not intentional and the failure was not anticipated. And therefore, even if you don't have a direct attack, and even if you don't have an indiscriminate attack as such, but you have specifically a disproportionate attack, that was ultimately due to the question of the failure to take all feasible and necessary precautions in the preparation of an attack, which delves you into the darkness of the targeting cycle and the intelligence cycle, and exactly what could have been done in terms of determining exactly the nature of the object and the individuals who were hit, and therefore the legal characterization of the attack. And we see that regressive structure of the argument almost every time that an attack is being recorded, analyzed, debated, adjudicated. And the more capable and the more sophisticated a military is and a military lawyer is, the harder it is to avoid the slippery slope into uncertainty in terms of a legal argument. And so let me start, and I'll go through this quite quickly because I think the present audience is very much aware of some of these aspects, in giving a few examples in how that uncertainty is peppered throughout the establishment of the law itself. So first of all, it starts with uncertainty in classification. It starts with uncertainty in the law itself, in trying to determine and classify what kind of targets are civilian and what kind of targets are military. And here we could really look at a lot of examples, including examples that have to do with the legal status of particular individuals, civilians directly participating in hostilities, and so on and so forth. But I used as an example the language from the Central IHL Treaty Additional Protocol 1 in its definition of military objects and the reference of nature, location, purpose of use, making an effective contribution to military action, and whose total or partial destruction, etc., offers a definite military advantage. Right? These are all contextual judgments, and these are contextual judgments that, to a large extent, defer or refer to knowledge, certainty, information, evidence that may be only partially available to observers on the ground and available in a more privileged way to the capacities of the attackers and the militaries. The example here in the picture is from the Al Jalaa target that was targeted in Gaza in May 2021, and the arguments, which were never entirely and fully clarified, that it hosted Hamas officials and that this was the justification. And the question and the debate about the precise use of this presumptively and presumably a civilian target and the extent to which some limited use of that justified the destruction of the entire target, right? And indeed, that debate and discussion around that target then went into questions of discrimination, in questions of proportionality, and to questions of precautions associated with the attack. This is not to say that a correct legal position or a position that is more plausible and more convincing cannot be found with respect to this particular target, as well as other targets, but to show the way in which something that begins by being obviously and clearly unlawful, either as a direct attack or a indiscriminate attack, has to go through this whole regressive legal argument. And the regression of the legal argument is also displayed in a number of different provisions that establish these steps in the legal argument, starting from a provision that is present in the Rome Statute of the International Criminal Court, and that identifies the direct attacks against civilians and calls for specifically identifying attacks that are intentionally directed against the civilian population as such, or against individual civilians not taking direct part in hostilities. And this is, the picture is an example of an airstrike against a hospital in Kunduz in 2015 in Afghanistan by US forces, which followed a number of clear indications, previously existing independent indications in terms of including the hospital in lists, in terms of a demarcation of the hospitals, in terms of communications from the hospital to attacking forces, and yet still ended at the hospital being targeted with a very significant loss of life. And in the debate around that hospital, the entire gamut of the regressive argument, all the way to the point of precautions and all the way to the argument that there was a mistake associated with it, was run. And that can also be found in recent revelations in terms of US targeting in Syria that have been done by Asmat Khan and other fantastic investigative journalists, and that have shown both internal aspects of the review of the attacks, but also the dire limitations of external assessors in terms of establishing these types of judgments and legality. And then the step back comes to the question of the indiscriminate attacks, the term not being identified as a distinct, except with one exception that we'll see, ground for individual liability in international criminal law, but identified as a distinct position in additional Protocol 1, and being defined, among others, it's only an extract of the article, as attacks which are not directed at a specific military objective, or those which employ a method or means of combat which cannot be directed at a specific military objective, either in general or in the circumstances ruling at the time. And here, of course, it is relevant to also look at the type of weaponry that is being used, and the type of weaponry being used in a particular context, especially in the context of urban warfare. And the picture here is from a strike in Yemen against a market in Al Fayoush, which is one of the focus points of the work that I have been engaged with in GLAN, in the context of working with Bellingcat and analyzing open source investigations, identifying and analyzing airstrikes, a topic to which I'll come back to at the end. And the argument by the Saudi-led coalition in this instance was that there were Houthi militants who were present in the market facility. So even if you start by identifying the nature of that object, the market, and presumably the individuals also being present in the market as civilian, the counter argument that there was a presence there of military targets, namely Houthi militants, takes that gamut towards their aggressive argument and weakens the initial pronouncement and proposition, and makes the argument that it is indiscriminate and therefore not an intentional attack against civilian targets, but an indiscriminate attack as such, which still is unlawful, but which still will be subject to a further, if you will, de-escalation of the argument. Leading to the question of proportionality being identified as a subcategory of an indiscriminate attack, but also being by itself a distinct legal principle and a distinct obligation to not launch attacks that cause incidental loss of life or injury to civilians that are clearly excessive in relation to concrete and direct overall military advantage anticipated. Here, then, we don't have a situation where military and civilian targets are targeted, together, right? And that there is absolutely no effort to distinguish between them. But here, the identification is that even if the primary attack is a military target, the incidental loss of civilian life and the incidental damage to civilian objects is and should not be excessive. And that is the rule of international humanitarian law, which, when introduced in the Rome Statute as a ground for international criminal law, is heightened in terms of threshold with the introduction of the words clearly and the word overall, which makes it harder to argue that this was indeed excessive and that this should lead to individual liability. And the key also word in this article and the formulation of this principle is the question anticipated, which directly refers to the judgment and the knowledge that was present in the military commander. Another relevant example is an airstrike that killed a Hamas militant in Israel in 2002 called Shahadeh, and that killed to a number of that led to the number of deaths of civilians, including children, and that led to an Israeli commission report, which ultimately decided that in objective terms the result was disproportionate, but that it was not anticipated, and that the process of the intelligence and decision making suggests that it was not anticipated, and therefore that there did not need to be individual accountability in that respect. Which brings us to the final step, if you will, in this process, the rule of precautions, the obligation to take constant care and to take all feasible and reasonable precautions in terms of verifying the nature of the object and in terms of minimizing the incidental loss of civilian life. a provision which is part of international humanitarian law and an important part of international humanitarian law, but that is not as such the ground for individual liability for war crimes in international criminal law, and which is indeed itself the ground, if you will, of a big battle within the international humanitarian law community, and between, to some extent, military and non-military lawyers in establishing exactly the extent of these obligations to take necessary precautions, as well as the ways and the tools that are available to establish whether these precautions have been taken. And that can also, going even further, as we'll see in a moment, take us into the depths of the targeting cycle, which is not always and necessarily concluded just before the strike is taken. And that can also involve questions of intelligence gathering, surveillance, and matters that we have very little access to in terms of establishing knowledge. So how do we respond to that? And how do we respond to all of these epistemological problems that exist both from an internal and from an external perspective? The fluid categories, the difficulties in drawing the line, the contextual judgments, the different weighing factors, the ways in which these categories change over time and can change over time, even in real time when the targeting decisions are being made. And that also adapts to the different characteristics of the specific conflicts, of the specific militaries are fighting these conflicts, the question of whether specific strikes were so-called deliberate, so they were done against objects and individuals that were identified and classified beforehand, and therefore that classification can be part of the legal argumentation, or whether they were conducted in response to the changing circumstances on the ground and were therefore what is called dynamic strikes, right? So for example, an informant on the ground sends information to the aircraft and the aircraft acts in that process. So there is a number of epistemological difficulties in establishing that sort of certainty and therefore establishing the capacity of drawing judgment. And the response has been the effort to seek certainty in the law of war and in the application and review of the law of war. And this has to do with rationalizing war, limiting subjectivity, professionalizing war, and it is also hoped through that process, humanizing war, including through the establishment of accountability for violations of the law of war. And yet the rationalization and the professionalization of war is also something that is best done by the most powerful and the most sophisticated technologically, as well as strictly speaking militarily, and by militarily in this case we will also include military lawyers, right? States and parties and militaries. And it can also be done in a way of, as it were, doing business in the context of war. And this is where I want to introduce, and you'll see that in the few slides that follow, the, if you will, ambivalence in relation to rationalization. That rationalization and achieving certainty is something that we seek for in knowing the truth and establishing legal truth, but it is also something that will always benefit more, to some extent, the more powerful actors in that respect. And that can be seen in some of the angles and aspects associated with certainty. So there are two main angles in the effort to establish certainty: a priori, so before the actual act, and a posteriori, so in judging the act afterwards. In terms of a priori, we have efforts to establish legal certainty through a number of ways. In a way, you can say that the law itself and the establishment and the writing down of the rules is such an effort, even though, as we saw by looking at some of these rules, it's still an effort which allows a great number of contextual, subjective, and epistemic uncertainty, right? But this is sometimes further enhanced through interpretation, through the issuing of guidelines, and actors like the International Committee of the Red Cross have played and are playing an important role in trying to establish some degree of guidance and certainty in that sense. And sometimes it can also be done by parties through the issuing of rules of engagement or through the issuing of specific directives and specific categorizations and rules that complement, if you will, the law in that respect. Some of the most famous ones, like the Obama era presidential guidance and directive in relation to signature strikes, also, I think, indicates and reflect the way in which some of these guidelines and some of these directives, A, can also remain vague, and B, can serve the party that is conducting the airstrikes in this instance. Another way is compiling lists on the ground, right? Establishing in the process of deliberative striking or in the process of also other organizations who are present in a particular conflict, the lists of specific objects and people, and identifying beforehand their status and their nature. Another way is an effort which sometimes is being done in terms of quantifying certain bright lines, saying that, for example, 20 civilians killed for one military individual killed is something that is disproportionate in an absolute sense, right? Which limits, if you will, the argumentation in terms of the contextual nature of the military advantage in some instance, but can also obviously lead to arbitrary and problematic types of quantification. And that's one of the reasons why it hasn't happened. The other reason is that it would tie the hands of militaries too much. But there have been some efforts. I recently was reading an older book by A.L. Weitzman called The Lesser Evil, in which he reports a conversation with Daniel Reisner, who was the head of the IDF legal unit at the time, and who was arguing for establishing very clear quantifications in terms of types of damage and types of and numbers of individuals killed in accordance with the principle of proportionality. And one of the arguments that he made was that this will be especially important to the extent that military technology is introduced. And this is the other aspect. And I can say a lot about this because I've researched it separately, and I can be happy to discuss this as well. But the process in terms of introducing advanced technology, either through the introduction of surveillance feeds introduced through drones, or through gradual establishment of artificial intelligence and autonomy in that process, is indeed a process of establishing a priori certainty. And the idea that law is codifiable not only in treaties, but also in code for machines. And that artificial intelligence is a guarantee against a faulty subjectivity that individuals will perform on the ground, either in terms of processing knowledge or in terms of their violent subjectivities and their indication to be disproportionate or indiscriminate in terms of the exercise of their violence. And this might be in practice applied either through full autonomy or through the interaction and increasing merging, if you will, of humans and machines in the targeting cycle and in the decisions associated with targeting. The picture is from a book by a roboticist called Ronald Arkin, who wrote back in the 1990s and who was one of the most enthusiastic proponents of the full codification of the law of war in artificial intelligence as a way of establishing certainty and as a way of humanizing war. And there are obvious, pushbacks with respect to that aspect in terms of the humanization, in terms of the power that this will give to more powerful entities, and so on and so forth. And then we have the a priori establishment of certainty. One of these is indeed through the development and application of a whole legal regime, international criminal law, and the role that international criminal tribunals, as well as international criminal law as applied in domestic courts through either exercising territorial or nationality jurisdiction or through establishing universal jurisdiction, and Mohammad will have much more to say about this, I'm sure, have the capacity and the possibility to ex post facto and externally establish certainty, establish judgment, establish knowledge, and establish accountability in relation to the conduct of war in this sense. And the evidentiary tools, to which I'll come just now, might be quite extensive and different in that process. But the epistemic tools specifically might also include inference, judging the mind of the commander, judging and reaching conclusions on the decision-making process that preceded the results that we observe on the ground from what we observe on the ground, or from a variety of contextual aspects that have to do with the evidence presented. Or sometimes it has also been tried bright lines, trying to establish bright lines in determining that certainty. And the picture here is from is related rather to an international criminal law case in Yugoslavia called Gotovina and Markac, which had to do with indiscriminate bombardment, and where the trial chambers tried to establish such a bright line, a specific line of error in terms of artillery, in order, using quite a great number of evidence, right, in establishing that bright line, including testimonies from a lot of weapon experts and the capacities and capabilities of the specific artillery used, in order to make the argument and find these two individuals guilty. Bright lines who were then relatively summarily, for the purposes of international criminal law, which means around 100 pages, were rejected by the appeals chamber, which thought, perhaps in a justified way, that the bright lines were absurd, but which used that finding, perhaps in an unjustified way, to strike down the entire decision of the trial chamber in this respect. And then they were, of course, received as heroes when they went back to Croatia. This has to do, of course, with some other aspects and pathologies of international criminal law, which have to do with intercollective judgment and international criminal law saying that it judges individuals and ultimately judges states. And it also has to do with a tension between ICL and IHL. But it also indicates the limitations of establishing certainty and epistemology in that respect. And finally, we have the development of specific evidentiary tools, and specifically the use of open source information and intelligence in seeking to establish the truth and seeking to establish the legal truth, as well as the material, social, and inevitably political truth. And here you have a tension, if you will, or potentially a cooperation between seeing the world and defining and determining truth from a distance using technology, and seeing the world and determining truth from the ground, especially in relation to individuals who have been involved in that process. And this is also reflected in the way that OSINT can be used alongside other types of evidence, including on-the-ground inspection, impact inspection, witness testimony, and so on and so forth. But it is also have to do with the way in which this battle of epistemology is being conducted in a lot of different spaces, including in the global space, including through actors and through activists and through investigators that are not present in the conflict at the time, which poses a lot of moral as well as epistemic issues. And there are aspects that have to do with the validity of OSINT as evidence in terms of its relevance, authenticity, and reliability. But there are also questions that have to do with what it can prove, right? What is the image analysis, the geolocation, identifying where the strike happened, the chronolocation, when it happened, trying to identify and establish the movements of the troops and the movements of the weapons that led up to the particular decision, in order to establish and recreate the actual targeting decision process, and therefore satisfy all of these rules that I spent most of this talk describing you and analyzing to you. And as you can imagine and as you can understand, the challenges that OSINT has to deal with have to do not just with establishing facts post-strike, but with inferring from those strikes, from those facts that are being established, exactly what was known beforehand. So with GLAN here, we have worked in developing open source intelligence, and specifically we have worked with Bellingcat in looking at airstrikes specifically that have to do with the Yemen conflict, and Bellicant developed a dedicated website related to that, and which has informed also litigation projects and contributing to partners litigation projects, for example, with respect to the challenges in terms of arms trade in the UK, as well as potentially criminal law projects in that respect. But in that process, and I am very close to concluding, in that process, that tension of the regression of the argument in relation to applying the law of war is continuously present, right? And in that process, and we are going very soon to release 3 reports on this, one on methodology, one on a mock trial that we conducted in relation with using OSINT, and one on OSINT and IHL drawing from the Yemen conflict. In that process, constantly, you have to make those arguments alongside those regressive points. And constantly, you have to try to recreate the world as it existed before this airstrike and for those who conducted the airstrike. And sometimes you can take inferences from geolocation and chronolocation. Sometimes you can take slightly more far-reaching inferences, saying that, for example, the sky was clear, and we know that the coalition has these particular capacities in terms of seeing what's on the ground. But sometimes you are always vulnerable to counter arguments in that respect. The 2 images from the Kuba funeral strike and the Daihan bombing strike in Yemen ultimately again reflect that, in that the Saudi-led coalition did the whole gamut, ultimately falling back on the mistake and on the precautions argument. And we see some of that OSINT already present in relation to Ukraine. This was one airstrike that was allegedly conducted against a kindergarten, and we had a first effort to geolocate that particular airstrike, and the immediate reaction of the Ukrainian foreign minister in terms of establishing those facts in order to take the matter to international criminal law. So I would conclude with one sentence, even though the slide seems longer. There is a battle that is being fought in relation to the soul, if you will, of the law of war, and in relation to establishing knowledge and certainty in the process of the law of war. And that battle can be fought along all the lines that I have tried to set out in terms of certainty and the lack of certainty and the epistemological challenges that are being presented in that sense. But that battle also should understand that absolute certainty, A, might not be possible, and B, might ultimately favor those that have more military and more technological capacities to impose it. And that ultimately we should know and we should act in accordance with the fact that there are different standpoint epistemologies, there are different truths, and that they are fighting it out with respect to the establishment of a type of legal truth that also fits the social truth that is experienced and lived with individuals, and that ultimately the law of armed conflict and the law of war will always be second best after the effort to abolish war and to not have war in terms of establishing judgment that is satisfactory in that respect. Apologies for going over time. Thank you very much. Look forward to your thoughts.
Thank you so much, Ioannis. It was powerful critique of knowledge. Thank you so much. Mohammad, please, your comment.
Thank you very much. Really, really powerful and knowledgeable presentation. I want to make 2 comments generally about the whole dilemma here. Is that the more knowledge and military capabilities and technical capabilities you have, that would assume sometimes that you will be refraining from engaging in, let's say, wrong or wrongful attacks, but that's not the case necessarily. What we've seen in New York Times open source investigation as well, but also accessing intelligence records and military records from the US military Department of Defense, that some of these areas were known to be civilians in northeast Syria in the battle the US conducted against ISIS, and they yet were targeted deliberately. And some of that, like a second round of investigation New York Times ran, that showed that a water dam was in the no bombing list by the US military, clearly was targeted in a direct strike that could put thousands of lives of civilians at risk. So that's why basically the prior incidents collection of information and try to distinguish between civilians and military objects, even with capable militaries that who respect the war laws and like try not to target civilians, that didn't necessarily happen. That's one, let alone when you deal with a government that deliberately targeting civilians with a deliberate purpose of killing them and abusing them and causing them unnecessary suffering. And here we're dealing with the Syrian government forces, especially the air forces. What we've seen in the nature of their work, not only they overlook the precautions that they're obligated to follow under international law, distinction, the proportionality, etc., but also they deliberately focused on causing unnecessary suffering to people, throwing barrel bombs on people indiscriminately from helicopters, just pushing them physically by a pilot assistant. That was one of the features, and these videos appeared a lot on social media, and I'm coming to that onset open source intelligence aspect of it. But also that what's so-called the double tab strikes, where the Syrian air forces will come and hit a market, and after 15 minutes will hit the same exact points a second time, just in an effort to kill the rescuers or to cause more unnecessary suffering for the people who gathered to basically see what happened or look for their loved ones among the destruction. So what we managed to do in the Syrian conflict, and that's also one of the powerful aspects of this conflict, where cell phones is introduced. There's good coverage of internet. Everybody has a good phone that films in a reasonable quality. And also we've seen a good improvement of the quality of the videos happen after 2016, where more 4K and high definition videos started to show up in social media. What helped us in that aspect, where everybody is filming, that we have a lot of video and footages available on YouTube. So our team at ASJAC, we managed to download 1.4 million videos from YouTube alone. And we managed to do this in a big scale, that before YouTube started removing videos for violation of terms of use because they're graphic in their nature or there's no copyrights, etc. And what we managed to do in our database, which is a relational database we developed in-house, Bayanat, is to try to triangulate these videos together, try to bring multiple videos and multiple footages of every incident and try to create the bigger picture of every incident. And that what helped us also to conclude, and this exposed clearly analysis and investigation, that these attacks were deliberate in their nature, and they were specifically designed in a state policy to cause unnecessary suffering to the possible extent against civilians. We've seen a couple of examples, but I'll give one or two. In a video, very graphic video of torture, the Syrian forces basically torturing a civilian and abusing the person, and group of civilians abusing them in a building that's unidentified. But the video showing lots of basically clear areas where you could identify if you're a resident of that area, if you know the building. A separate video show up in a separate YouTube channel from a separate person showing dead bodies of several people, that you could do a basic analysis of the video, match the clothing of those people to the same clothing of the people who were abused in the first video, but later with a witness statement from the area, with geolocating the area on a map, that is actually a military hospital where those people were workers in that hospital, and that area was attacked specifically in specific time into 2012. And there is enough videos and satellite images can show either movement of troops or showing the forces engaged in this attack. So putting all this information together could present feasible evidence that could be used in cases. The second thing I want to mention and highlight is the universal jurisdiction aspect, because unfortunately Syria does not have a tribunal so far. The conflict is still ongoing and there's no ICC active jurisdiction over Syria. Syria is not a party to the Rome Statute. Neither a Security Council resolution could be passed with the Russian involvement in the conflict. So the universal jurisdiction cases in Europe indeed is using this very evidence being gathered by open source and being gathered by activists and human rights organizations. Two quick examples is the Caesar photos, although that's a bit an insider witness information, which is the pictures were gathered by a military photographer who defected from the Syrian government and had thousands of pictures of dead bodies he had to document for the military police. But what the court in Koblenz went forward and did was to try to geolocate some of the locations appeared in those pictures in the backyard of security agencies and a military hospital, and try to show them in a map, does actually this building match what it's being claimed in the statement of this person? These pictures were taken in the backyard of a intelligence branch or not? And it did, it matches, and that verifies the statement of the witness. And now we see it again in a trial in Frankfurt where a Syrian doctor is being prosecuted for allegedly abusing prisoners who were transferred to hospital for medical attention. The prosecutors are insisting and asking the defendant to draw a map of the hospital where he served and in the military hospital where he worked. And then they're comparing it to the satellite images they collected of the same hospital to see how much he's providing information. Torture and executions of that hospital happen in a specific certain areas of the hospital, not in the overall hospital. And that's what the prosecutor is trying to get access to by comparing this information. So just to give a final comment that that created a lot, the open source intelligence and the availability of information in this wealth created a lot of evidence that would have not been prosecuted necessarily without videos, without satellite images, without putting all these information together. It's unfortunately not contributing in the case of Syria of improving the war laws respect, because again, it's a state policy to violate those laws. It's not actually by mistakes or happen for just not following the exact rules. But also, as we've seen when the US intervened with the coalition against ISIS, every single party to the conflict, whether Turkey, Russia, the US-led coalition against ISIS, did not actually respect those laws either. Not to the same level to the Syrian government when it was a state policy to violate laws and kill civilians deliberately. But the others didn't care much, like the videos and the images showed from Northeast Syria. We're involved in a forensic project in Northeast Syria to try to fight the faith and identify the remains left behind ISIS with a team opening mass graves in Northeast Syria and doing forensic work. Not all the graves found in the area belong to executions by ISIS, but some of them belong to indiscriminate killing by the US, where like to kill 1 or 2 ISIS members, the US leveled some buildings under assumption there's tunnels starting and ending under those buildings. And that all went without accountability, for at least for now. I'll stop here. I would love to hear also from Tom, and thank you again, Ioannis, for the remarkable presentation.
Thank you, Mohammed. So from a critical knowledge to the power of knowledge. Let's hear Tom, please.
Thank you very much, and thanks to Ioannis for a fantastic and thought-provoking presentation, and to Mohammed for those comments. So when I was listening to this, I was thinking about various different levels on which this discussion is occurring, and it struck me that we can think about the forum, we can think about the remedy or form of accountability, we can think about the rules in question, we can think about the roles of the lawyer, different roles that a lawyer might play in these respects, and thinking through some of the differences or the diversity within each of those layers, forum, accountability, rules and roles, may either open some avenues for more productive truth efforts where we're not necessarily looking for a particular standard of proof that would be acceptable in a criminal court, but some more political standard of proof that Ioannis was mentioning at the beginning, but using the law to get there and using the tools of the law to get there, but also ways in which the fact of criminal law in the background in particular actually muddies a lot of the discussion in some of the other fora, and that might be part of the problem, that we have various different fora in which we could be having this discussion, but the fact that there's the possibility of war crimes accountability sort of narrows the discussion in many of the other fora where we might be having that discussion. And so we think about fora, obviously criminal courts is one of them. Even within the criminal forum, it strikes me that there are several different forms of remedy that we might be discussing, or several different forms of accountability, or several different levels. So for example, even the arrest warrant stage at the ICC, and thinking about complementarity and making arguments about whether the state's engaged in adequate investigations and efforts to bring perpetrators to justice and so on, arguments there and establishing or getting past the hurdle of admissibility and showing that complementarity hasn't been satisfied, that itself is a significant indictment of the state. And so there's a lower standard of proof, of course, and there, when thinking about the structure of argument and the inferences that can be acceptably drawn, and when we might shift burdens, or when we might think about enough having been established on one side to require some kind of response on the other, that's a different debate and a different set of arguments from the arguments about criminal accountability of specific individual in the end. And what the state has to do in responding to challenges with respect to whether it's satisfied complementarity is not just say, well, look, there are all these different rules that you have to look at, but that's actually show that it's done something, that it's engaged in some kind of investigation. And so there's at least one step there. Then in addition to the criminal accountability step, there's obviously human rights accountability, accountability on other kinds of levels, such as the arms trade that Ioannis was mentioning, where certainly in human rights courts, there's more of a willingness to either shift burdens or suggest that, well, given that any further information on this would require access to classified information, at this point we have to say the state has to say something to establish that the inference drawn is not an acceptable one. This is particularly the case, for example, in Inter-American Court of Human Rights judgments on things like enforced disappearance, where if you can show enough, then the burden shifts to the state, or there's an acceptable finding of fact, unless the state can show something to the contrary. But then beyond just these different legal fora, there's also the political forum, and we can think about both the ways in which the law and legal arguments around specific examples of possible wrongdoing might be used to mobilize political action within a particular state, but also possibly mobilize dissent within the state, or mobilize some kind of reaction internal to the government, not just in the polity more broadly. And in those fora, I think one of the things that Ioannis is pointing us to is that if we have criminal law in the background, there's this danger that the state will, first of all, focus a lot of the discussion on the criminal law standards. So particularly when we're thinking about 8.2b4, for example, and clearly excessive civilian loss in the context of an attack that's on some kind of military objective, and therefore we're reduced to discussing proportionality. The fact of that criminal law standard kind of dilutes the value of the underlying law of armed conflict standard, but also allows the state this posture where it can take a position ultimately that there was some kind of mistake here, or there was some kind of error, or we didn't quite comply with the law of armed conflict, but don't worry, it wasn't a war crime. When if war crimes law wasn't there in the background, that wouldn't be a particularly desirable position for the state to take, to say, yes, we violated proportionality here, and that's all there is to say about it. And so I wonder if part of the problem there is just the very fact of war crimes law in the background actually distorts the degree to which we can have the kind of political discussion that we might have using the law as a tool of some kind of shared normative standard for that political discussion. And what that means, particularly for organizations that are operating at multiple of these levels. So this goes to the question of roles, that lawyers can be involved in each of these different fora. Obviously, in the criminal law fora, it's lawyers who are engaging in the argument in the courtroom, but also in the political context, when we're seeing when we get the reporting from the New York Times about various different strikes, and lawyers are then debating it on blogs or on Twitter or in public fora in media as public talking heads. One thing I think might be a challenge here is can legal experts play multiple of these roles at the same time, or is there a credibility issue in playing multiple of these roles at the same time? You certainly notice that a number of legal experts will look at information that's been made public and say, well, I don't have all the facts, so I can't comment on it. To which one might think, well, you can comment on the facts that are available and say, well, these are the inferences we can draw given these facts, and this is why there would need to be some kind of response from the state, not just to say, there's classified information here that you don't have access to, and so you don't fully understand what the targeting decision was in this particular context, or what precautions we took, and so on and so forth. But actually demand more and say, there's evidence of significant civilian damage. And so if we're talking about proportionality, it's not enough to say there was a military objective and we limited the civilian damage. Tell me exactly what the military advantage you think was that could possibly outweigh this level of civilian loss. And can lawyers be involved in that kind of claim, that kind of argument, without compromising their ability to engage in these other fora? Or is it the case that lawyers really have to stick to one of these lanes or the other, such that invoking international humanitarian law as an expert, you're limited in terms of which of these kinds of debates you can engage in? And certainly in some of the public discussion around these issues, it strikes me that there's some tentativeness, at least in some of the commentary, to engage in that debate in the political forum. And I don't know if it's because of credibility concerns outside of that, and I don't know the degree to which GLAN has faced this, for example, because I know you're operating in human rights contexts, criminal contexts, and thinking about multiple different standards and burdens that you might be bearing in different contexts. And that seems as though it's a forum that's just not adequately utilized here, that there's a way in which it's been diluted by some of these other forums. And then the final thing just on the rules is some of these rules are more amenable to that kind of shifting of the burden of argument. So particularly proportionality, there's obviously the evergreen problem of proportionality of how do you weigh incommensurate values, but that can also be an opportunity to demand an accounting of what exactly is the claim here regarding how this civilian loss can be justified. That they have to, that in a sense, you can, at least in the political forum, if not in the criminal law forum, shift the burden to the state and say, you caused this much civilian harm. And yes, this has to be evaluated against some military advantage, but then you need to be forthcoming about what that could be. And simply saying, well, classified information, we can't get into all the details, or we'll issue an investigation, etc. There can be a bit more of a demanding posture, at least in the political forum, for how to respond to that kind of strike. And I think that's true also of indiscriminate strikes and precautions to a certain extent. And so the Gotovina case that you were mentioning earlier, it strikes me that that was really distorted by being in the criminal forum. That it looks pretty clear that this was an indiscriminate shelling campaign. And it's only once we get into the criminal forum where there's all this concern about, well, exactly where do we draw the line? And how do we make sure that this meets the criminal threshold, that we can get to a result where there's an acquittal and the sense is that therefore this was justified. Whereas if we were focusing on demanding of Croatia an accounting of what exactly was going on here and how it could possibly be justified to engage in this kind of attack, that there would maybe be more of a shift. And I wonder whether we can think about, for example, the ICRC's work on explosive weapons in populated areas as trying to perform that work to say, this line should be over here, and anything the other side of it, you should be justifying, rather than us getting muddied in a debate around exactly what was the weaponry used and exactly what was the density of civilian population in this particular location at this time and what were the military advantages and so on. The final thing I just wanted to say with two very quick points is I think the point on resource disparity is really important, especially when we're thinking about the political forum, because it's there where states with significant resources or significantly higher resources are able to engage in that response and push back to the kinds of arguments they've been suggesting in ways that they're much more able, let me put it this way, they're much more able to shift the debate onto their terms. And so it makes it harder to see exactly how these techniques might work. On the other hand, some of them are also subject to policies or democratic accountability that might be more demanding precisely because of the resources they have available. And so it's partly a question of how you shift the political will in those discussions to be demanding in that respect. And the final point is just on open source intelligence. So, right, I guess there's one...
Excuse me, Tom, I was wondering whether we could give Ioannis the possibility to respond now, because we
yes, sure, okay, go ahead, sure.
And then you can add the final point during the conversation.
Thanks.
Go ahead. Yeah,
Thanks.
go ahead. Thanks.
Thank you both for very both useful also for me in the way that I move forward with this project, and thought-provoking comments. So yeah, and also I'm glad that that Mohammad is here to give us a little bit more, like, in terms of the practical application of OSINT also beyond targeting, right? Because that's also an important aspect in the way that evidence is gathered and judgments are made and accountability is sought in that respect. And I'm also grateful that you mentioned, Mohammad, the question of double tap strikes, because that's very much a practice that I think accentuates both the capacities that technology is giving us and also the different fora in which argumentation about the consequences of that analysis can give us. And both also the potentially kind of still existing limitations in terms of inference, but also the pushing back to the burden of proof and saying that, and the Al-Quba funeral hall strike that I mentioned earlier indeed is an instance of a double tap strike, and there is a presence of a video from the ground that was authenticated, geolocated, analyzed, and chronolocated to show that the second strike happened very soon after the first strike, and therefore allowing the types of inferences that those being struck were first responders, as well as potentially countering the even initial counter arguments in relation to a mistake in terms of the identification of the overall object in that respect, right? And as to follow from what I was saying, and also in relation to what Tom was saying, that might not lead to an ultimately entirely conclusive analysis and position from the point of view of open source analysis, but it does definitely increase the inferential value of the analysis and increase the burden of proof, and might also invite and invoke, right, a shifting of the burden of proof in terms of the state to justify that particular actions. I think Tom's point about the role of ICL is especially relevant, and it's also something that I've been thinking about quite a lot. And it's, there is a general critique, I think, of international criminal law that it's a colonizing process in the conceptual and moral sense, right? It is a process that takes over all other legal regimes in order to establish and respond to a sense of justice or a sense of retribution in the way that it judges on the behavior of actors on the ground, and coming together with its collective judgment implications, it plays an additional distorted way. But it also especially works in that respect in its relation to international humanitarian law. I would only add to what Tom said that the behavior of state lawyers and military lawyers has been observed, that when they are being asked by a state to justify and to provide arguments in relation to a particular strike, the role that ICL does and the position that if we can show that this was not a war crime, we're fine, has been seen. And that is especially problematic. And it really, it's almost like the limitations and the weaknesses, both in the law, but also in the enforcement of IHL, has led to us putting faith in ICL. And yet the putting disproportionate faith in ICL is kind of referring back as a default position and reinforcing all of these weaknesses that IHL has, which is a tragedy, right, when you're fighting in that respect. So I very much welcome Tom's points about the different fora, even within ICL, but also more broadly. And indeed, the arms trade aspect is a very good example, because our argumentation in the context of the arms trade aspect is in showing patterns, right? In showing patterns of behavior in order to show that there is a probability for future violations which will justify the provisions of the Arms Trade Treaty and the obligation of the states to not export weapons, right? But even in showing those patterns, we have had to fight through the kind of micro slippery slopes in the showing of all of these specific incidents that inform the overall pattern, right? And you need to be quite aware of all of these slippery slopes, even if you're making an argument in a different fora or with a different sort of legal regime and so on and so forth. And the techniques in terms of reversing the burden of proof, either in political, rhetorical, advocacy aspects, or in terms of the use in different legal fora, I think is, you know, it's really a lot in terms of keeping in your mind as a practitioner and as a lawyer and as an activist in that respect. But it is really very much where we need to be trained on, rather than on purely establishing legal certainty in accordance with a particular type of rule, right? And you mentioned also the Human Rights Forum, and that's something that I did not include in my talk, and I'm grateful for that you brought it up. And it's also quite interesting to see the way in which those patterns of investigations apply in this context, and the way that they can also be applied by the same institutions differently in relation to different situations and different states. So, you know, 3 examples: Russia versus Georgia and the so-called chaos, right, of war, Carter versus Russia and the assassination of Litvinenko, and the inferential work that the European Court of Human Rights did in that instance to find the violation in times of peace, but still, and the Hanan case in relation to Germany, and actually deferring to the state's, you know, conduct of an investigation in applying human rights law in a situation of armed conflict, which shows that even within a particular forum, within the specific rules, there's still, you know, different ways in which this battle for knowledge and judgment is being fought. So, yeah, and that's all I have to say, as I see also that our time is running up, and I'd like to thank both of you for very interesting comments.
I want to thank the 3 of you for an amazing discussion. I wanted also to say that the mention of the kindergarten on February 25th is particularly chilling and gives a particular meaning to our effort to talk about this in a way that is dialogical and hopefully makes discursive epistemological progress. I leave it to you if you want to say one last word. I will have to leave very soon to the next engagement, but Mohammad or Tom.
No, I just want to give another example about Russia quickly. I saw this in media as well. Apparently, President Putin was live on TV with his military council, with the defense secretary, with the foreign minister, with everyone, discussing what they're going to do about Ukraine. But then a couple of hours later show up, yes, the watches, exactly, announcing the independence, recognizing the independence of the 2 new states. But then apparently the media, the videos of their watches showed actually he signed the agreement, and it was filmed before he met with his cabinet. And it was that a predetermined decision from his mind, although he was deluging his nation. Basically, he is consulting with his cabinet, and this is the best consultation advice he received. So this is all what Ioannis mentioned, that the social truth and the political truth about events, not only criminal accountability evidence aspect, it's really important. And halfway through the meeting, President Putin took off his watch because he realized that this is being filmed and the time is being captured, but it was too late after media pointed to this issue. It's unfortunate what's happening clearly in Ukraine, but I'm hopeful that activists learned a lot, and I know great people. Bellingcat is doing some work, and to be honest, so we'll see more evidence of what's happening there.
Thank you all, and of course to be continued also with the general public who will have access to this recording later.